Mr. Short?
Yes, Your Honors.
Good morning. We note that you were appointed under the Criminal Justice Act, and the court wants you to know that we deeply appreciate your willingness to accept the assignment.
I appreciate that. Your Honors, and may it please the court. My name is Lee Short, and I represent Randall Robinson. If it pleases the court, although 5 issues were briefed, I believe that I would like to discuss the first issue that I guess I'd lovingly refer to as the dirty cop testifies against a dirty cop. It deals with the issue of whether there's a Brady violation by the government for not disclosing the fact that their primary witness in the conviction, Charles Weaver, committed illegal and dishonest acts prior to the trial of Randall Robinson, and that was not disclosed. I think it's a pretty exciting issue with huge ramifications, dealing with when you impute conduct to the prosecution. As this court's aware, there's 3 elements to any Brady violation. First, it's got to be favorable information. Second of all, it's got to be suppressed. And third, it's got to be material. Dealing with the first element, I don't think there's any question that the ability to impeach the government's key witness would be favorable to Mr. Robinson. So I think that element is unquestionably met. When we're talking about the second element, as far as suppression, obviously the court's aware, it doesn't have to be purposefully suppressed by any means. It has to be not disclosed and not able to be obtained by the defense. In this case, former Detective Charles Weaver's misconduct, including forgery and lying to his superiors, and possible theft, was not disclosed to the defense prior to trial. In no way was it possible for the defense, and never has it been alleged that the defense could have obtained this information prior to Mr. Robinson's trial. And so I think the second element, as far as suppression, has certainly been met based on the fact that that was not turned over. I think the easy thing to do, and I think that in several of these cases, although there's not a great deal of case law on this issue, what happens is the courts generally go to the third element of materiality or prejudice, and whether that's been shown. Usually because when you are dealing with a police officer or a member of the government team that committed misconduct or illegal acts prior to trial, you're dealing with some form of tangential or collateral issues. And so whether it's material is obviously one of the biggest questions you can ask, whether that would have changed things. And I think...
Do you find any authority on this question of the obligation to disclose that's analogous, where you have a witness and some impeachment material that's unrelated to the case?
Well, I think there's a huge amount of case law that says that if there's impeachment that's known to the prosecution or to the police about their witnesses, it has to be disclosed. I don't think anyone would debate that if the prosecution knew that their witnesses had done dishonest acts in the past or had prior felonies, that they would have to disclose that. But I think where this becomes different is it's a police officer's private misconduct that was not disclosed. And as far as authority on that particular issue...
Well, or any witness, but go ahead.
I think, and I think it becomes a little bit more of a burden on the prosecution, certainly in the context of it's a true member of the government team as far as law enforcement. I mean, law enforcement in federal court can sit at the table when they're the lead detective for the prosecution. And so they're certainly a member of the government team. But
well, did this witness, was he the case agent who sat at counsel table?
He was, because this was kind of, and to answer shortly, no, because there were two.
Well, then why are you bringing that up as a reason?
Okay, and maybe that's not a good argument, and so I'll move on. But as far as case law on this particular issue, there are cases cited. A few of them are district court cases, and obviously that's not super persuasive, other than to have some...
Well, it can be persuasive if it's well-reasoned.
And it has fantastic reasoning, and I think
What's your best case that you think is analogous?
Your Honor, I think that the best case as far as being analogous would be Banks, which is actually a Seventh Circuit case where they were there was an ongoing investigation into a crime lab analyst, and the crime lab analyst had basically used some government funds that were put into her private account.
Not much discussion in that case, though, of this prosecution team question.
Not a lot of it, but the question was, even though the government didn't know about it, is it still a Brady violation? Even though it's also tangential to the issue of whether that was actually cocaine. And the Seventh Circuit held that it was a Brady violation and should have been disclosed as possible impeachment of the crime lab analyst. And I think it's a stronger case here because we're not dealing with something so verifiable as cocaine, whether it's cocaine. I mean, whether someone has misused their credit card or government funds on their credit card, and whether it's cocaine is too, it would be hard to sell a jury necessarily on the fact that because they misused some credit card funds, their testing of whether this is cocaine is wrong. But I think that what the court said in there in their analysis of materiality is very important, because what they said is you've got to presuppose almost on this question that the government's that the impeachment would have actually worked, that it would have actually impeached the credibility of that individual, which would be the crime lab analyst. So for purposes of analyzing in that case, the court said, let's take it to the extreme and say maybe the jury would find that it wasn't cocaine, and so then you wouldn't have a conviction. And I think that that's very important. So when you look at materiality or prejudice in this case, what you would look at is whether the government would have been able to make their case or there's a reasonable probability they wouldn't have been able to make their case, assuming that the jury did not believe that Detective Weaver, former Detective Weaver, was being truthful to them.
As I understand it, the timeline, Detective Weaver's dishonest acts occurred prior to the trial, correct?
Correct.
But they were not revealed to anyone but himself until after the trial?
I think that they were established. The forgeries were obviously established before, but whether the government or law enforcement knew, they did not know until a month after.
So how do we analyze that? The fact that this bit of impeachment information is only in the head of the detective, and if he reveals that to the prosecutor, he basically incriminates himself.
Absolutely. And I think that you analyze it on the same way you would any other favorable information known to the detective. I mean, if the detective knew that another witness in the case was a liar and had lied to him 100 times, I think that he would have to disclose that. And so it doesn't create any different burden. The problem is it does make it difficult on the prosecution, because police officers generally aren't going to come forward with their own misconduct. The problem with, naturally we want to blame someone when we're talking about Brady, and it's absolutely not a blame game, and it's not the fault of the prosecution. It's just that Randall Robinson deserves a fair trial with this information.
So your position is, under sort of the Brady analysis, it doesn't matter whether the prosecutor could have gotten at that information or not. The fine line is it's there.
Absolutely. And it wouldn't be any different if it was any other kind of information. And the fact, and Kyle's is very important in this case, because it changed kind of the analysis, and it said we're going to impute what police officers know to and members of the team, the prosecution team, to the prosecution. It never made an exception for their own misconduct, and the analysis, the three-pronged analysis of beneficial, suppressed, and material, doesn't have any exceptions, and Kyle's didn't have any exceptions for an officer's own misconduct. And
why is the impeachment material in this case, given that Kaiser also witnessed most of the activity?
Well, I think you've got a few issues with that. First of all, you've got the fact that Detective Weaver was the head detective for that investigation, and he dealt with the confidential informant. He testified about making phone calls to Robinson, and he was, like I say, he was the only one that wrote a report, which I think is very important. I mean, we're talking about a trial that took place several years later, and Kaiser's testimony is that he did witness the transaction. However, he took no photographs. On the recording, it didn't sound like Randall Robinson. The the apartment complex had no ties to Randall Robinson. The apartment had no ties to Randall Robinson. The vehicle that Randall Robinson was supposedly driving had no ties to Randall Robinson. And so you're talking about a fairly weak case as far as the delivery